No other major democratic country in the world follows the system under judges appointing judges. That is not there in the world.
In April 2026, a fire broke out at the Delhi residence of a sitting High Court judge. At first, it seemed like just another accident. But what firefighters found inside wasn't just ash, and the institution responsible for appointing that judge didn't investigate, didn't explain. It just transferred him. This is how India chooses who decides your fate in court. What you're about to watch is a formal debate. 8 of India's most formidable legal minds, one stage, arguing a question that's usually kept technical, complicated, out of reach. Should Parliament have a say in who becomes a judge? Because the answer to that question decides something fundamental. Whether the institution meant to protect you from the state can itself be influenced by the state.
This House believes that judicial appointments should have legislative interference. I repeat, this House believes that judicial appointments should have legislative interference. It is a question that goes beyond the separation of powers and to the very soul of the Collegium system.
Before we get to the debate, you need to understand the scale of this. As of mid-2025, India had 371 vacant judge positions across high courts. At the same time, 178 names were already recommended, cleared, waiting, some of them for over 2 years. In one case, an advocate in Allahabad waited 27 months just to be appointed, and yet other names were cleared in days. No explanation, no transparency. This isn't just delay, it's selection. And this debate happened right in the middle of that. Dr. Subramanian Swamy opened the debate with a simple observation. India is the only major democracy where judges appoint judges. No elected representative can question them.
Judicial independence is vital, but independence does not mean isolation. A calibrated legislative role brings transparency, accountability, and democratic confidence to judicial appointments. In other words, I think what we are saying is that at present, the Indian judiciary, especially at the top level, which is the most important, is totally a law unto itself.
In the United States, a Supreme Court nominee faces public hearings, days of questioning, on record. In India, 5 judges meet privately, and that's it. No record, no reasons. Then came Sai Deepak, and he did something unexpected. He didn't defend the Collegium. He reframed the entire debate.
I am not here to defend the institution of Collegium. Rather, I am here to define what is legislative interference and push back against it. That's how I see it. Because the question was not whether there's a choice between a collegium and legislative process. The question is whether there should be legislative interference in the in judicial appointments. That's how I see the question.
According to him, the real question isn't control. It's the difference between a voice and a veto.
My sense is interference would be not the right to vote, but the right to veto. If the legislature has the final word on judicial appointments, then that becomes interference in my submission, which is to say, what would that bright red line be, which if crossed would translate or transgress into interference? So you have consultation, you have concurrence. Where do you think interference falls within which basket? I would say concurrence.
The state is the single biggest litigant in India. It appears in lakhs of cases every year. So who appoints the judge in those cases isn't theoretical. It's personal for everyone involved.
If you look at the statistics, the state is actually the most litigious entity in the country, going by any number of studies, including the National Litigation Policy. And when the bargaining power between two parties is practically non-existent, I would expect that you offset that difference in bargaining power by ensuring maximum possible neutrality of the person who operates or who sits in that particular position.
And then he said something that divided the room.
You are not in a position to compare yourself with an America, New Zealand, Australia, or any of these countries, not yet. I'm sorry to say that. I don't think you're in a position to actually say that where democracy has been fully democratized, where the power of adult suffrage, universal suffrage or franchise is capable of being bought for a biryani packet or a bottle of alcohol. and which is still largely the truth regardless of which part of the country you go to. This is not limited to any particular state or region. I believe that this is a fairly pan-India phenomenon. There, I think, is unity in diversity.
Justice Siddharth Mridul brought a different perspective. He had been inside the system. He had seen how the Collegium works, and he disagreed, but not in the way you'd expect. He went back to the Constitution, to Ambedkar.
The Chief Justice is a very eminent person. But after all, the Chief Justice is a man with all the failings, all the sentiments and all the prejudices which we as common people have. And I think to allow the Chief Justice practically a veto on the appointment of judges is really to transfer the authority to the Chief Justice, which we are not prepared to vest.
The original design never gave judges the final word in appointments. That power came later, through interpretation, not intention. Akhil Sibal issued a warning. Reform sounds appealing, but the legislature is not neutral. It is the government, and the government is the biggest litigant in the country.
The legislature is comprised of members of a party or parties in majority that form the government of the day, the treasury benches as it were. The members of the opposition are those who wish to form the government in subsequent elections. So whether it's the treasury or opposition members, they will always have an institutional interest, a bias in wanting to be able to influence judicial decision making, because when in government, regardless of the political party, it will help to dilute the constitutional check on government excesses.
So if judges begin to owe their positions to that same government, every decision becomes complicated, because ruling against power comes at a cost.
Now imagine if you're a litigant before the court and you have a case against the government, comes up before a judge who's been selected and appointed by that government. Would you not reasonably harbor a doubt about the independence of that judge from the government?
Gopal Shankaranarayan described the Collegium with quiet sharpness.
In 1993, I can understand the judges were showing imagination and saying, we don't have another system, let's try this one out. Where, coincidentally, the judges who authored the judgment were themselves the first, second, and third members of the Collegium. So they themselves gave themselves the power to finally decide who their judges are going to be, right?
And then came the numbers. In a country of 140 crore people, one woman on the Supreme Court bench, just one. And in 2019, a sitting High Court judge wrote directly to the Prime Minister, alleging casteism, alleging nepotism, not from outside the system, but from within it. That's what makes it harder to ignore.
We have a scenario today where out of 34 judges of the Supreme Court, we are in, and I've said this before, and I'm using the expression again, disgraceful position where we have only one woman in the Supreme Court of India. This is not acceptable at all.
Prashant Bhushan made a striking claim. The government already has a veto. It just doesn't use it openly.
So when they don't like, suppose 5 judges are recommended by the Collegium, the government doesn't like 2 of them, they okay and issue the notifications for the other 3, but hold back these 2 that they don't like without saying yes or no. The only power that the government has is to say no, and thereafter, if the Collegium unanimously reiterates, the government has to issue the appointment notification. But they have not been doing so, with the result that this government has effectively got itself a veto power over judicial appointments. And the result is that we have reverted back to a situation where the appointments were being made by the government, because effectively now the appointments are being made by the government.
In March 2025 alone, 13 Collegium recommendations were pending across multiple high courts. No reasons given, no timeline, just silence. And in at least one case, even the Collegium recorded that a transfer decision was changed after a government request. They wrote it down in their own resolution. Sanjay Hegde took a different route. He told a story. A Republican leader appointed to the US Supreme Court by a Republican president went on to become fiercely independent, so much so that the same president later said it was his biggest mistake.
Justice Earl Warren was proved so independent that President Eisenhower later said that was the biggest damn fool mistake I ever made.
The point was simple. No system guarantees good judges, and no system guarantees bad ones. In the end, it comes down to the individual.
If you feel that the judiciary must be pliant to the government because it helps a party which you vote for, operate under the assumption that a party can lose power and it cannot constantly stay in power for eternity. What happens when the shoe is on the other foot and when the opposition, so to speak, or a party, so to speak, that you don't vote for, that you have a particular anathema for, comes to power? Where do you run then? Because by then you would have contributed to the compromising of the judicial establishment altogether, leaving absolutely no resolution for your woes.
As the debate came to a close, one argument stood out. Not legal, not technical, something deeper. A question about power, about trust, about the kind of system you want to live under. And finally, it came down to this: a single question, a civilizational one.
If you're interested in protecting the basic structure of the Constitution, which preserves the identity of the Indian Republic, are you better off with a pliant judiciary or a relatively independent judiciary, despite its problems, is the only question you have to ask yourself.
The audience voted, and the opposition won. Every speaker in that debate agreed on one thing: the system is broken. What they disagreed on was how to fix it, because without real independence, justice itself becomes uncertain.
Judges are willing to hold everybody and every entity accountable to a standard which they will not hold for themselves.
5 judges. No criteria, no reasons. Now you know what that really means. If you know someone who still believes the system is completely independent, send them this. Because this conversation is just getting started.
And keep your political and ideological proclivities out of this question, because this is more a question of protecting the institution. And here's something I've always said in my public discourses, I'll just repeat this once. If you feel that the judiciary must be pliant to the government because it helps a party which you vote for, operate under the assumption that a party can lose power and it cannot constantly stay in power for eternity. What happens when the shoe is on the other foot and when the opposition, so to speak, or a party, so to speak, that you don't vote for, that you have a particular anathema for, comes to power? Where do you run then? Because by then you would have contributed to the compromising of the judicial establishment altogether, leaving absolutely no resolution for your woes. And those who were in the opposition at least until 2014 must remember this, because ultimately it was the judiciary that managed to come out with several verdicts which turned the tide, if we really want to get political about this. And I wish Mr. Bhushan was around here to actually make that point. So at least when it comes to institutional respect and institutional responsibility, I would suggest, notwithstanding my public positions on certain issues, keep your ideological proclivities outside the question of institutional importance and institutional independence, because without institutions, all of us will be subject to the whim of a despot, whoever that may be.